Recently, we have incoming information about the way the FISA courts are operating, and it's bad news, and I'll start with that. Particularly, we have a lawsuit for records about the infamous FISA court proceedings related to General Flynn, Carter Page. Now, the government's told us they can't confirm or deny anything's happened as it relates to General Flynn, but they did confirm to us, as a result of the president's brave effort to disclose information about what was going on. He declassified documents related to the Carter Page materials earlier this year. They confirmed to us there was a Carter Page FISA application warrant process, and we received, Judicial Watch did, the FISA applications targeting Carter Page, a former campaign advisor of President Trump. There was the initial warrant filed in I think it was the end of 2017, just before the election, of course. In 2016, just before the election. And there were 3 renewals. The most recent one filed in June of 2017 by Rod Rosenstein to the benefit of Robert Mueller, who's the special counsel. So the special counsel is responsible for these FISA court warrant applications. You have, obviously, Rod Rosenstein responsible for the warrants. You had also James Comey sign on to them, Andrew McCabe sign on to them, who was the FBI #2, who was fired in disgrace, and then Sally Yates, the anti-Trumper acting Attorney General for a time, #2 in the Justice Department under Obama, also signed on to them. So 3 of those folks have been fired, Yates, Comey, and Mr. McCabe. But the warrants also show they were heavily redacted. They show they relied on the Clinton DNC dossier without telling the courts it was the Clinton DNC dossier. They pretended or withheld that information from the courts. They also used Christopher Steele as a source, even though at least for the warrant applications, the 3 warrant renewals, he was deemed after, let's put it this way. In October, the warrant was filed. They used Christopher Steele as a source. They didn't tell the court that he was working for the Clinton camp. So really outrageous. And then shortly after that, Judicial Watch found in another case, we got FBI documents about Christopher Steele. The FBI in November of 2016 cut Steele off as a warrant, as a source, saying that he was deemed unworthy as a confidential human source. And they told him not to collect intelligence. Well, it turns out he continued to be used by them to justify these warrant applications. Now, they suggested there were problems with him leaking to the media, to the courts, but they didn't tell the courts that they cut him off as a source, deemed him unworthy, deemed him not suitable as a confidential human source. That certainly should have colored what the courts might have done, or that information might have colored the court's analysis as to whether they agree to accept these applications. Now, one of the things we're interested in terms of getting these applications was, did they have hearings about what was going on here? Did they discuss any of this with the courts? You know, it's one thing to have the 4 corners of the application in front of you, but maybe they talked about this with the courts in person. Well, it turns out, incredibly, there were no hearings by the courts on these FISA warrant applications. These historic FISA warrants targeting Carter Page. And look, you hear Carter Page, don't be distracted. It was all about Donald Trump. If you read these warrant applications, they're available on our website at judicialwatch.org. You'll see it's all about targeting Donald Trump. And we had asked for the transcripts. The Justice Department initially told us there were no transcripts. We asked the court just a few weeks ago, we filed a motion with the FISA court, the Foreign Intelligence Surveillance Court that handles these proceedings, asking for them to release transcripts. We hadn't heard from them. But finally, the Justice Department, late last night, filed a brief in our case suing for these records. And this is what they disclosed to Judicial Watch. I'm going to need my glasses, put my disguise on here. The National Security Division of the Justice Department, FOIA, consulted Office of Intelligence, again with the Justice Department, to identify and locate records responsive to our FOIA request. The Office of Intelligence determined that there were no records, electronic or paper, responsive to our FOIA request with regard to Carter Page. The Office of Intelligence further confirmed that the Foreign Surveillance Court considered the Page warrant applications based upon written submissions. It did not hold any hearings. So these courts rubber stamped spying on the Trump team. That's how I read it. They didn't hold one hearing on the initial application, not one hearing on the renewals, even though in the renewals, the Justice Department starts making noises about the source having problems, Christopher Steele. And they knew it was targeting President Trump, and they didn't bother holding one hearing. Isn't that outrageous? And these were 4 different courts. So you had the initial application, and then 3 subsequent renewals. It wasn't before the same judge. It was 4 different federal court judges. And this is the way the FISA court works. It's the Foreign Intelligence Surveillance Court. These are proceedings that are conducted in secret. They're not subject to public disclosure typically. This is the first time ever FISA court warrant applications have ever been released. First time in history. So it's rare to be able to get them. Various federal court judges are assigned to terms on this Foreign Intelligence Surveillance Court, I think by the Supreme Court, the Chief of Justice of the Supreme Court, in this case, Justice Roberts, Chief Justice Roberts. So there's a revolving door of, not a revolving door, but essentially the court changes. The judges on the court change from time to time after their terms are up. So, but not one of these federal court judges who were given this awesome responsibility to conduct these secret court proceedings, these classified proceedings, where the government comes in and asks for spy warrants on American citizens because they're deemed to be acting as agents for a foreign power. And they were throwing this dirt at President Trump, and not one judge thought enough to hold a hearing. And I tell you what, if they're not doing this on spy warrants targeting President Trump, you can bet they're not doing it on any spy warrants or in sufficient ways on spy warrants targeting any other American citizen. It seems to me, if this is the way it behaves, this is the way the court is on spying on President Trump, can you imagine what it is for someone who's not well known? And I've been told typically they don't hold hearings on these spy warrant applications. They just stamp them, rubber stamp them. Now, maybe in some cases they think they can rubber stamp them, that it's appropriate that, look, the Justice Department and the FBI, they go under oath, they promise the courts that this record is complete, and there's enough information for the court to decide one way or another based on the papers. And maybe the courts say, hey, look, I don't need to bring them in and question them. I can read. But it seems to me, when you look at the evolving, the changes in these warrant applications, especially with respect to the key source, Christopher Steele, the court should have held a hearing.